a man with a documented history of domestic violence, arrested multiple times for threatening his girlfriend with a gun, ends up indicted for illegally possessing firearms under federal law. Lower courts, applying a recent landmark ruling, strike down that law as unconstitutional. Suddenly, the federal prohibition on gun possession by people subject to certain domestic violence restraining orders is gone, at least in parts of the country. Then the Supreme Court steps in. In June 2024, in United States v. Rahimi, the court ruled 8-1 that this federal statute, 18 U.S.C. paragraph 922G8, is constitutional. It allows the government to temporarily disarm individuals when a court has found they pose a credible threat of physical violence to an intimate partner or child. This wasn't just a narrow win for gun safety advocates. It was a critical clarification after years of uncertainty about the Second Amendment's limits. Yet outside legal circles, it flew under the radar. Most coverage focused on the drama of the post-Bruen era rather than this practical, life-saving outcome. So here's the question I want to put to you right now. Do you believe someone under a court-issued domestic violence restraining order with a credible threat finding should still have the right to own a gun? Drop your thoughts in the comments below. I'd love to hear where you stand and why. Let's step back and understand why this matters so much. The Second Amendment reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed." For most of American history, courts treated this as primarily about militias. That changed in 2008 with District of Columbia v. Heller, where the Supreme Court, in a 5-4 decision written by Justice Scalia, held that the amendment protects an individual's right to possess firearms for lawful purposes like self-defense in the home. It struck down D.C.'s handgun ban, emphasizing that handguns are the quintessential self-defense weapon. Then came 2010's McDonald v. Chicago, which applied that right to the states through the 14th Amendment. But these cases left big questions open. Does the right extend outside the home? How do we judge modern gun laws against the Constitution? That brings us to 2022 and New York State Rifle and Pistol Association v. Bruen. In a 6-3 opinion by Justice Thomas, the court struck down New York's proper cause requirement for concealed carry permits. More importantly, it replaced the old balancing tests, where courts weighed government interests against individual rights, with a new standard. If the Second Amendment's plain text covers the conduct, the government must show the regulation is consistent with the nation's historical tradition of firearm regulation. No more interest balancing, just text, history, and tradition. This shift unleashed a flood of challenges. Lower courts began scrutinizing everything from assault weapon bans to felon in possession laws under this historical lens. Some restrictions fell, others held up. Confusion reigned. And then came Zaki Rahimi's case. Rahimi had a restraining order against him after multiple incidents of violence toward his girlfriend, including brandishing a firearm. The order explicitly prohibited threats or use of force and found he posed a credible threat. Federal law barred him from possessing guns while that order was in place. He challenged it facially, arguing it violated the Second Amendment. After Bruen, the Fifth Circuit agreed with him, finding no sufficiently similar historical analog. The government appealed. The Supreme Court reversed. Chief Justice Roberts, writing for the majority, explained that history shows the founding generation disarmed those who posed threats of physical harm. Surety laws required people suspected of future violence to post bonds or face jail. Going armed laws punished carrying weapons to terrorize others. These weren't identical to modern restraining orders, but they reflected the same principle. When someone credibly threatens violence, society can disarm them temporarily to prevent harm. The court stressed this isn't about permanent bans or broad categories. It's targeted, judicially determined, and temporary, tied to the threat. Roberts noted the law only applies if the order meets strict criteria, like a credible threat finding or explicit prohibition on force. Rahimi's order did. Importantly, the decision clarified Bruen's test. History doesn't require a perfect twin. It demands consistency with underlying principles. Requiring exact matches would freeze the law in 1791 amber, ignoring how threats evolve. Many scholars argue this was a course correction. Rahimi pulled back from an overly rigid reading of Bruen that could have invalidated too many common-sense restrictions. Now, let's address a couple of common myths. First myth: Rahimi gutted gun rights or opened the door to massive new restrictions. Not at all. The court reaffirmed Heller and Bruen. It upheld one specific, narrow prohibition tied to judicial findings of danger. It does not allow blanket bans on gun ownership for broad groups without evidence of threat. Second myth: this only affects domestic violence cases. While focused there, the reasoning strengthens the idea that dangerousness can justify disarmament. It supports laws disarming those who pose clear risks, like in felon in possession challenges where non-violent felonies are at issue, though the court has denied many such petitions recently. What does this mean practically for everyday Americans? If you're a law-abiding gun owner with no history of threats or violence, nothing changes. Your rights remain robust. But if a court finds, after due process, that you pose a credible threat in a domestic situation, you can be temporarily disarmed to protect potential victims. This has real-world impact. Domestic violence often escalates when guns are involved. Statistics show firearms increase the risk of homicide in abusive relationships. By keeping guns out of those specific hands during the order, the law aims to prevent tragedy. This isn't about taking guns from millions, it's about targeted intervention where danger is proven. And remember, this is for educational purposes only. If you're facing any personal legal issue involving firearms or restraining orders, consult a qualified attorney. Don't rely on a video. What do you think? Has Rahimi struck the right balance between rights and safety, or gone too far one way? Share in the comments. These discussions help us all think deeper. Looking ahead, Rahimi may stabilize some post-Bruen chaos. Lower courts now have clearer guidance. History allows disarming the dangerous. We're seeing ongoing cases, like challenges to drug user prohibitions or private property carry rules. But this decision shows the court isn't heading toward unrestricted carry or total deregulation. 3 key takeaways. 1. The Second Amendment protects individual self-defense rights, but not for those credibly threatening violence. 2. History matters, but it's about principles, not identical replicas. This flexibility preserves reasonable, targeted laws. 3. Judicial findings of danger provide due process, making restrictions constitutional when narrowly applied. Understanding this area of law matters because it affects real lives: victims seeking protection, owners exercising rights, communities balancing safety. Clarity here empowers everyone to know where the lines are drawn. Thanks for watching. If this helped, hit like, subscribe for more breakdowns, and share your thoughts below. Stay informed. Knowledge is the best defense.